My case was Ben F.B. It was heard September 26, 2005 by our own Susan Eschite. Some background information on the case. Ben F.B. is an 18-year-old student from Roosevelt High School in Des Moines. Throughout his educational career, he had excelled at school. He excelled so much, in fact, that he was enrolled in a specialized program for gifted students that took place at Central Academy off campus during the afternoons. Parts of his classes also took place at a place called the Papa John Center. He was enrolled in AP classes and maintains a higher than 3.0 GPA. Previously in life, he was diagnosed with ADHD, oppositional defiant disorder, and dysthymia. Some minor disciplinary issues exist, like truancy and tardiness. While they are documented, he was not considered by the school to be a disciplinary problem. An altercation took place on February 18, 2005, involving Ben. As Ben was leaving Central Campus to go to the Papa John Center for his gifted program, an associate saw him light a cigarette outside the entrance of the school. The associate asked Ben to go to the office, and Ben refused to go. So the associate reported the incident to the vice principal, Mr. Glaw, who went over to the Papa John Center to meet Ben. While over there, Ben admitted to Mr. Glaw that he smoked, but he refused to empty his pockets. Mr. Glaw then went to grab Ben's arm above the elbow, and the altercation turned physical. Ben knocked Mr. Glaw's glasses off of his face. Following that, Mr. Glaw attempted to grab and hold Ben. To avoid the hold, Ben struck Mr. Glaw numerous times and yelled profanities at him. He escaped the hold and he ran away. And as he was running away, a flask with alcohol in it fell out of his pocket. Mr. Glaw contacted the principal, who got in the car and went to find Ben. He found him and brought him back to the high school with the SRO. The SRO then determined that Ben would be charged with a public offense, and he was also charged with 4 violations of the school conduct code. He was charged with intentional display of disobedience and disrespect. He was charged with assault and battery, disorderly conduct, and unauthorized possession. Following all this, the principal recommended to the Department of Student Services that Ben be considered for expulsion. So an expulsion team was formed, interviews were done. People that were included on the expulsion review team were Ben, his parents, administration, and several teachers. Their findings led the expulsion team to recommend expulsion for the rest of the 13 weeks of school, placing Ben in an alternative program to be able to finish his credits. The superintendent agreed to expel Ben. Following the decision to expel, the family asked for a meeting to see if Ben's pre-existing diagnosis of ADHD was directly related to the altercation on February 18th. So a manifestation determination meeting was held on March 3rd. Included were Ben and his parents, the principal, the school psych, social worker, educational consultants, other administrators, and teacher. During the manifestation determination meeting, they held a program review. They determined that Ben had 24 of the 21 credits needed to graduate, but he still needed economics and American history to fulfill his graduation requirements. They determined that Ben was achieving to his potential. He had a 3.2 GPA, scored a 32 on the ACT, and 1390 on the SAT. There was not an IEP or a 504 plan in place, and there were no behavioral goals, a BIP, or an FBA that were documented his behaviors. Also during the program review, the staffing team concluded that Ben's disability did directly control his behavior that day. So his behavior was a manifestation of his disability. The administration team disagreed. They thought that it was not a manifestation of his disability, and they recommended to expel him and place him in an alternative placement for the rest of the year. Though there was not 100% consensus, the parents did eventually agree to transfer to the alternative setting. There was an expulsion hearing by the Board of Education March 10th of 2005. The school board concluded that Ben's diagnosis of ADHD did not in and of itself prove that he was impaired by his condition, and Ben's diagnosis did not substantially limit a major life activity. So the board sided with administration, decided to expel Ben, transferring him to an alternative setting to complete his necessary coursework in order to receive his diploma, but he was not allowed to walk with his class at graduation. So there are some things that we need to remember when thinking about discipline of students with disabilities. We know that students with disabilities cannot be suspended for more than 10 days if the misconduct was related to their disability. Remember, in this case, some of the team thought the misconduct was related. Another part of the team thought that it wasn't. The law prohibits the application of disciplinary action that would change placement without applying procedural safeguards for a student with documented disabilities. And if a parent files a complaint concerning FAPE involving an eligible child, then the child would stay put in their current educational placement. The key word in this sentence is eligible, as Ben was never yet determined to be an eligible child. The same provisions are applicable if the school had knowledge of the child's potential disability. So students that are not yet identified could be protected by those same provisions. For conditions deemed that a district had knowledge that a child may have been eligible, if a parent expressed their concern in writing, if the child's behavior or performance demonstrated a need, if the parent had requested an evaluation, or if the teacher or LEA expressed concern to the director of SPED. In the case of Ben, none of those four things happened prior to the misconduct. So the parent says that Des Moines Community Schools does not have a legal standing to use due process to challenge the IEP team's determinations on eligibility and manifestation. They cited the Iowa Rules for Special Education and the Supreme Court's decisions in Rowley and Honig versus Doe. The parent also claims that the school knew of the disability before the misconduct. The school claims that the district was unaware of the private diagnosis and treatment until the manifestation meeting, which was following the misconduct. Parents had a private evaluation done. Parents were seeing counselors outside of school, but these were not things that they communicated with the school. The parents neither expressed concern or requested an evaluation prior to the misconduct. The school says that child fine did not apply, as none of those four factors were existent. And obviously, with his 3.2 GPA and his high test scores, Ben was not adversely affected in academic performances by his disability. The school finishes by claiming that the appellate's reason for invoking the IDEA protections was not to secure SPED services, but was to avoid the consequence of expulsion. In the end, Des Moines Independent Community School District and Heartland AEA prevailed. The expulsion remained in effect. My personal reaction is I agree with the decision that was made. Reasons for my agreement: Ben was not a previously identified student. In fact, during the manifestation determination meeting, the parents didn't disclose all of the different evaluations and diagnosis that Ben had a history of, even when they were in the manifestation determination meeting. Parents never requested an evaluation for IEP. They never requested a 504 to assist with behavior. The school was not made aware of many instances of behavior until after the misconduct. So some of the facts that they used to support that Ben had a standing behavior disorder were instances that happened outside of school that the parents never did tell the school about. Some implication for us as leaders and aspiring leaders is just to make sure that the correct people are at the manifestation determination meeting. In this case, the correct people were present. They were very well represented. And even with all of the right representation, there was not consensus between the members of the meeting if the disability impacted the behavior or not. So I think it just shows how important it is to have the right people. If they had been missing some key players, the determination meeting could have gone differently. That would have changed the whole outcome. Remain cognizant of the basis of knowledge or child find provisions. In this case, the district was aware of those 4 different provisions, and they were aware that none of them had been met. That protected the district in the end. And I think the final thing is that just having staff awareness of their statements and assessments. During the expulsion review case, some teachers were interviewed, and while they said things that were true to them, that there was behaviors in their classes, they really said some things that might have made it seem like the district did have previous knowledge of a disability. So I think that perhaps having staff awareness of the words that they're saying, and then even having staff awareness of maybe those child find provisions would be helpful. So some questions for consideration. What conditions would have to change for you to think that the school was responsible to enact child find provisions for Ben? How would this outcome have been different had a behavior plan been in place in the past? What lessons should Des Moines Community Schools take away, or what changes might they want to make following this court hearing? Thanks so much for listening.